Welcome back to my channel. If this is your first time here, I'm glad you found this series. We explore the right of disposition, the legal right to control what happens to your body after death, and how to make sure your wishes are honored clearly and without conflict. This episode focuses on Kansas, where state law gives you full power to decide who handles your final arrangements, as long as you take that power in writing. In Kansas, you can legally choose who will make your funeral, burial, or cremation decisions by completing a durable power of attorney for health care decisions or by signing a written funeral declaration. Under Kansas Statute 65-1734, you can name a person called your designated agent who has full authority to carry out your final wishes. Once your declaration or power of attorney is properly signed, dated, and notarized, that person's authority overrides all others, including family. If you don't leave written instructions, Kansas law decides who has that authority. First, the person you appointed in your written declaration. Next, your surviving spouse. Then, your adult children, a majority if there's more than one. After that, your surviving parents. Then your adult siblings, followed by other next of kin in the order of inheritance. If no one is available or willing, a public official, coroner, or county authority may make the decision. That order is outlined in Kansas Statute 65-1734, and it's what funeral directors follow when no written plan exists. In Kansas, time also matters. If a body remains unclaimed for 24 hours, the coroner or medical facility must begin arrangements for final disposition, typically burial or cremation, unless someone steps forward to claim responsibility. While that 24-hour rule allows for quick decisions in emergencies, it also shows why documentation is crucial. Your written declaration ensures the right person is notified and authorized immediately. If you're estranged or no contact with your family, the state's hierarchy still applies unless you've put your wishes in writing. That means a relative you haven't spoken to in years could still control your arrangements. By naming your own agent, you remove uncertainty and make sure your voice, not theirs, decides what happens. Kansas law doesn't specifically reference chosen names or gender identity in its funeral or disposition statutes. If you use a chosen name or your gender identity differs from your legal records, include that information in your written declaration. Note your preferred name, pronouns, and how you wish to be remembered. Give copies to your designated agent and funeral home so your identity is respected the way you intend. Before we close, let's talk about a few common mistakes people make when it comes to final arrangements in Kansas. First, not having their form notarized. In Kansas, an unsigned or unwitnessed document isn't valid, even if it clearly expresses your wishes. Second, thinking a healthcare power of attorney automatically covers funeral decisions. It doesn't unless that authority is specifically written into the form. Third, not keeping copies in the right hands. Your agent, your attorney, and your funeral home should all have a copy on file. Avoiding these mistakes ensures your wishes are clear, respected, and legally protected. Thank you for watching. I hope this helped you understand how Kansas handles the right of disposition and why getting your documentation in order is one of the most thoughtful things you can do for yourself and your family. If this information helped you, share it with your family, friends, or anyone in Kansas who may not know their rights. Conversations like this protect your peace and your legacy long before that time ever comes. Be sure to like, comment, and subscribe for more state-by-state episodes in this series. And check out the rest of my disposition playlist to see how laws differ across the country. I'm Bella, but this is your life, your legacy, and your choice. even after you're gone.